So this was the information that I was going to do as a live today, but I decided to go ahead and pre-record it because this topic has been wildly misreported on, and it's difficult and it's confusing. So I wanted to try to say it as plainly as I can. And it's kind of hard when you're live because you got a million things going. It's still nerve-wracking to me. So I didn't want to get it wrong, so I'm doing it this way instead. So what I have here, we're going back to the motion to compel, document 262, filed on the 2nd. And this was prepared by Kevin Fritz, who I think is a really good author of legal documents. Him and Mitch and Brian, all of them, but oh my goodness. Do you guys love Ellen? I love her. I'm so glad they added her. They needed a woman, and she is absolutely brilliant from what I've seen so far. But now I've gone off the track. So this is how it all started. So we all know by now that they're in the discovery phase. And it hasn't been easy. It's kind of been like pulling teeth, trying to get these documents from each other or any information. And what we've come to is that Blake has to prove intentional infliction of emotional distress. And that's actually the main topic of today's whole episode. I've got the California 2025 guidelines for how to prove this. It's another one like malice that's got a very high bar. The best way to prove it is mental health records. I put a link to Not Actually Golden's videos. She made 4 yesterday, and they were amazing. And she touches on this topic. So anyone that's taken offense about them demanding her medical records, when you have a high bar like this that you have to prove, there's really no other way to do it. It's really difficult to prove this just by saying it, or just by having your friends and your family say it. It's possible, it's happened, but it's rare. It's much better when you have this absolute proof. So this part's old news. I think everybody's heard that she said, well, fine, if you're going to make me produce this, then I'd rather just dismiss these claims, which is kind of ridiculous. But she wasn't willing to just truly let it go. She wanted it dismissed without prejudice. Probably, knowing her, hoping to keep this window open to bring it back on when it was too late to request discovery. So Team Justin, they're like, no ma'am, we're wise to your games by now. We're not going to take your word for it. We want this filed, documented, and before the judge's eyes. And so this letter was born. So for relevant background, she claimed that the conduct of not just Justin, but all of the Wayfarer parties severely impacted her physical, psychological, and emotional well-being. And this is a quote taken directly from her first amended complaint, document number 84, paragraph 361, that she suffered and continues to suffer substantial damages, including, but not limited to, severe emotional distress and pain, humiliation, embarrassment, belittlement, frustration, and mental anguish. I think that kind of describes what the Wayfarer team has actually been through. They're the ones that have been accused of being perverts and predators and schemers. But you do you, Blake. And then these other two point to the negligent infliction of emotional distress. And they say these are not merely garden variety claims. These are serious claims. And you'll see that in a moment. Then they mention that this is routinely exchanged in cases involving claims for physical and emotional injuries. So, say you're in a car accident, you're badly injured, and you say you broke your back, and you're suing the person who hit you. Now, if you go to court, you can't expect to just sit there in the courtroom and say, I broke my back. Here, ask my mom. They're going to want your medical records. They're going to want your x-rays. They're going to want, if you had any kind of surgery, they're going to want your surgeon's reports. They're going to want to know what the prognosis is for the future. How serious are your injuries? So just like that, these are medical injuries too. They're mental health injuries, but just like you would expect them to look at your physical medical records, you can expect it in these kinds of cases. And so they list the 3 things that they asked for and say that she refused to disclose them. According to this footnote, we see that she has mentioned it in her initial disclosures, but she didn't identify her mental health care providers, so there's no one they can even subpoena. And again, like I said yesterday, it makes me wonder if these even exist. Maybe there is no medical or mental health care provider that saw her for these claims. It goes on about standard procedure and her obligations. It shows how they had a proposal, but when they submitted it, Blake's team came back with it edited. what you call the red line version, even though they used green, not red. But that's an edited version when attorneys are going back and forth trying to create a document that's acceptable to both sides. It comes back and they've changed with prejudice to without prejudice, which to me, and probably all of you, is a scary prospect when it comes to Blake Lively. You want this stuff locked down, you want it in print, you want it filed in the court. You don't want to take her word for it. And that's when they said that Wayfair parties cannot agree to any withdrawal that enables Miss Lively to refile them. So that's why they brought this to the court. And so what they want the court to do is grant a motion that 1, Blake has to disclose the names and addresses of these perhaps non-existent medical and mental health care providers that treated or examined her, produce all reports and treatment notes, and deliver HIPAA forms for her medical and psychiatric records for the last 4 years. Now, someone had commented about it being 10 years, but they got that confused. This is just a citation of a case. In this case, the motion to compel was granted for 10 years worth of treatment records. They asked for 4. They're just saying, this is normal. This was granted in this case in 2020. They're not asking for 10 years, so that's a lie. So in the footnote, because they're not supposed to run directly to the judge, so of course they always note, we tried. These were our efforts. We met, we conferred, it didn't work out. Last resort, we came to you. And the issue for this was about these confidential claims. Here we see the red line version where they changed with to without and made a couple of other changes, but it seems like the only one that was an issue was the without. So like I said, we're going to go through the 2025 California charges for proving intentional infliction of emotional distress. So this is the most up-to-date information. It may be updated by next year when the trial comes, but this is what she's going to have to prove. This is what will be provided to the jurors under California law for them to decide if it were to go actually to trial, which now it looks like this part of it won't be. So first of all, there are 4 essential factual elements in order to prove this. The first one is that the conduct was outrageous. Now, we all have a pretty good idea about what the word outrageous means, but in a legal sense, this is how it will be explained to them. For conduct to be outrageous, it must be so extreme as to exceed all bounds of that usually tolerated in a civilized community. So, I don't know why I pictured on a bus. For some reason, I'm never on a bus, so I don't know why that popped into my head. But say someone is being rude and obnoxious on a bus or on a train, somewhere in public that you have to be. Do you like it? No. But are you going to get up and call 911 or get their name and number to try to sue them later because of the conduct? We might say, oh, that's outrageous. But this word tolerate helps define it a little bit. We're going to sit there, we're going to roll our eyes, we might talk to ourselves, we might text someone, we might film it. But in fact, if we continue on our route and get off at our stop, we are in fact tolerating it. Now, if he or she are assaulting someone or strip their clothes off and get naked, of course we're not going to continue to tolerate that. We are going to call for help, or we are going to just get off the next time this bus stops. We're not going to stay and just finish our ride. So that's an example. Yeah, it may be something that makes us uncomfortable. Yes, it may be something we don't like. Yes, it may be something we wish we weren't having to endure. But are we tolerating it? So remember, these are extreme situations. And the second point backs that up. Liability does not extend to mere insults, indignities, threats, annoyances, petty oppressions, or other trivialities. Things where there is no occasion for the law to intervene. So, if someone's just being annoying and you walk up to a police officer and complain and he's like, well, he's not breaking a law, there's nothing I can do here. Think of it like that. And the last one, where someone's feelings are hurt. Now again, all of this information, this doesn't come from me. This comes from California standards. Behavior may be considered outrageous if a defendant, 1, abuses a relation or position that gives him power to damage the plaintiff's interests. So again, the word damage. It's not just annoying, not just upsetting, not just making you cry. It can be pretty bad, but does it actually damage? Number 2, knows the plaintiff is susceptible to injuries through mental distress. So for example, I knew a woman who worked at a bank. The bank was robbed, It didn't happen directly to her. It happened to a different teller, but she was there when it happened, and she was really shook up afterwards. Lo and behold, her bank gets held up again. This time, at her window. She has a gun pointed at her head. She's gone through some severe mental distress. Now, she ended up on disability, but when someone you know has been this distressed, and you come up and you decide that it'd be funny to pull a joke, pull out a toy gun and point it at her, it's not like someone just doing that to me. I don't have that kind of history. I don't have that kind of trauma. I might not think it's funny, but laugh along with it and be like, oh yeah, you're a jerk. Don't do that. But if you do it to someone that you know has something like PTSD because of the very thing that you are antagonizing them with, now we're talking outrageous. And that kind of goes into number 3, acts intentionally or unreasonably with the recognition that the acts are likely to result in illness through mental distress. So, do you see the difference in just outrageous behavior like, oh, that's outrageous, and legally, how you legally define outrageous? It's quite extreme. So back to these 4 elements, that was outrageous. The second element is that the defendant intended to cause emotional distress or acted with reckless disregard of the probability that plaintiff would suffer. So that's not just recklessly like, oh, I wasn't thinking. So how do you define reckless disregard of the probability that plaintiff would suffer? Again, I don't want to provide my own definition. Here's the official one. Defendant knew that emotional distress would probably result from his or her conduct. So it's more than just the new guy comes in, doesn't know about the woman's past with the gun to her head, and starts telling a story about something like that. That's not reckless disregard for the probability. That's truly not knowing. This is talking about you knew that it would probably result in this. So this is someone who knows about this person's trauma and does it anyway, thinking they'll be fine. The second one, defendant gave little or no thought to the probable effects of his or her conduct. Probable effects. It's not done innocently without thinking. It is not essential to liability that a trier of fact find a malicious or evil purpose. It is enough that the defendant devoted little or no thought to probable consequences of his conduct. So again, this isn't the absent-minded, oh, I didn't know. This is a person who knows the situation, knows it's a possible or probable consequence, but does it anyway. They don't have to be like, oh, I'm going to upset her, but they have to know that it's a possibility and do it anyway, just thinking everything's going to be fine. The requirement is satisfied by a showing that the defendant acted in reckless disregard of the probability that the plaintiff would suffer emotional distress. And now we're back to the third factual element, that the plaintiff suffered severe emotional distress. So, maybe you did all those things, the person was upset by it, but was it severe emotional distress? And we'll get to that definition too. But the fourth one, that defendant's conduct was a substantial factor causing plaintiff severe emotional distress. So it was something specific that this person did that caused it. But all of these have to be there. So now let's get into what severe emotional distress is. It includes suffering, anguish. Now think about anguish. Anguish is not a little thing. Anguish is losing someone in death. Something debilitating, really. Fright. Not just a little scare. Horror. Horror is beyond fear. Nervousness, grief, anxiety, worry, shock, humiliation, and shame. It's a lot of really big emotions. Severe emotional distress is not mild or brief. So, someone can scare you really, really bad. But if you calm down in the next 10 minutes, half an hour, by the time you go home from work, that's brief. But if it sticks with you to where now suddenly you can't go out in society, or when you're out, you're terrified the whole time, you feel like you're going to be attacked, and that feeling lingers, that's what we're talking about. As it says, it must be so substantial or long-lasting that no reasonable person in a civilized society should be expected to bear it. There are people who end up with agoraphobia after something very traumatic. It's talking about things like that. And it also says, no reasonable person. So it has to be a reasonable standard. Now it states something here. It says it's for the court to determine whether on the evidence severe emotional distress can be found. It is for the jury to determine whether on the evidence it has in fact existed. That can sound a little bit confusing. It's like, wait, doesn't the jury decide? What does this mean the court determines this? Let's talk about what that means. So in the courtroom, there are two distinct triers of the case, the judge and the jury. They have different jobs. The judge decides all questions of law. He's doing that now, actually. He's determining, does it meet the legal standard? If any of these claims in these lawsuits don't meet the legal standard, that's when he will grant motions to dismiss. So he's determining right now whether there is enough there to meet the legal standard to continue with a lawsuit. He's not deciding if someone's guilty. He's deciding, is there enough there to meet the legal standard for this to continue to trial? So that's what the court determines. Now the jury determines questions of fact. Did the plaintiff actually suffer? The judge is not deciding right now whether or not Blake actually suffered. That's left to the jury. The jury has to decide, was it severe? They also have to decide, did the defendant do what he's being accused of? And finally, if he did, was it intentional? So, for example, what the jury's going to have to decide if it comes to trial, if we look at some of the things that Blake has accused the Wayfarer parties of, she says Jamie peeked at her while she was breastfeeding. He says he didn't. And that if he did, he absentmindedly made eye contact with her while she was talking. So the jury has to decide, did she actually suffer from this situation? Was it severe? Did he do it? And if he did it, did he do it intentionally? One would expect severe would be him staring for some time or trying to take a picture or making comments about her breasts. That's what the jury has to decide. Did a he said, she said glance during a conversation while she was breastfeeding in the presence of multiple men, does it amount to severe emotional distress by this definition? So when it says high bar, do you see how high this bar is? You've got to get 6 to 12 people to find that this happened. So severe emotional distress means emotional distress of such substantial quality or enduring quality that no reasonable person, there's that word reasonable again, in civilized society should be expected to endure it. So ask yourself that question. If you're a woman and you're breastfeeding and you've invited a group of men, your producer, your director, I don't remember who else was present, but it's a whole work meeting, and you regularly breastfeed in front of these people. So you invite them to come to your trailer and you're breastfeeding, and at some point, one of them looks over at you. That's her accusation, not he kept looking, but he looked at her. If you're a reasonable person, would you say that you shouldn't be expected to endure that? That you are so traumatized that you need the help of a mental health care provider to help you deal with it? That it's substantial? That it's enduring? Not just, I didn't really like it. It made me uncomfortable. Oh, that jerk, he shouldn't have looked at me. And this is why things like medical records are often required. So just to show how that would go, you would start with one question. Was the defendant's conduct outrageous? Yes or no? If your answer to question 1 is yes, then answer question 2. If you answer no, stop here, answer no further questions. Question 2, did the defendant intend to cause emotional distress? Or did the defendant act with reckless disregard of the probability that the plaintiff would suffer emotional distress, knowing that the plaintiff was present when the conduct occurred? Yes or no? If the answer to question 2 is yes, then answer question 3. If the answer is no, stop here, answer no further questions. Number 3, did the plaintiff suffer severe emotional distress? If your answer to question 3 is yes, then answer question 4. If you answered no, stop here, answer no further questions. Number 4, was the defendant's conduct a substantial factor in causing plaintiff severe emotional distress? Again, if the answer is yes, move on. If not, stop here. And then you would go on to sorting out the plaintiff's damages. So that's how it will go for each and every one of these causes of action that actually make it to the trial. We had our first elimination so far. Well, potentially. It's not formally yet. But it seems as though 2 of her causes of action are going to be eliminated. This could continue to happen. And then whatever are left by the time it comes to trial, those will be what the attorneys are trying to prove on both sides, Some of those may be done away with in the process of the trial. By the time this goes to the jury, the list will probably be smaller than it is now. But that's the process that they're going to go through to get through each of these causes of action. So I want to go through all of them like I did this one and just make these little short videos to show under the law what these definitions are. Just so we can educate ourselves, because as we're talking about each of these things, we all kind of question, does this qualify? Are they guilty of this from a true legal standard? So let's go through all of these. Then you'll be all set. When you're talking about it, you'll know what you're talking about, or at least have an idea of what you're talking about. And who knows, maybe some of you will end up on a jury at some point. But I see there was a bunch more filings, and I'm so far behind. Got to finish working on my amicus brief one, because several of you have questions about this 47.1, and that's the one that's going to get into that. So I really want to get that one finished. Till then, this is Cassidy O'Connell saying stay well and stay tuned.